Dennis O'Rourke.
Mr Speaker, New Zealand First will continue to support this bill, which implements almost all of the Law Commission's recommendations. And of course, the Associate Minister has already reviewed the main changes in the bill. So what I want to do is to focus on 4 of the improvements made by the Justice and Electoral Committee and why I think in particular they should be supported. And I'd like to begin really by just commending the Justice and Electoral Committee for the work it's did. I think that it went through the bill very well, and it was a great pleasure to be part of it. Now, the first improvement that I want to focus on relates to hearsay statements and to Section 16 of the Act. There are types of police records that, as we know, are not inherently reliable, and in the current Act they should be excluded, rather, from the definition of the term business record in Section 16. And the reason for that is that hearsay statements made by witnesses or comments made by them in interviews by people who say that they have important knowledge to contribute aren't inherently reliable and ought to be excluded, because reliability is absolutely vital and fundamental. So I think that's an important improvement that the committee has made to the bill, and one which deserves to be supported. The second one relates to Clause 30 and the need to prevent the misuse of video records. Now, the Justice and Electoral Committee has made some important improvements to clarify actually the Act on this matter, and there are 2 of them that I want to mention. The first one amends Clause 30 to clearly specify the duties and restrictions relating to those video records which parties and lawyers have access to. And what the amendment will do is to ensure that defendants and their lawyers are still able to view video records and to determine whether to oppose or not what is in them, but are able now to do so in an appropriate way and at an appropriate place. And that's a significant improvement, and it's very important that access to those video records are available, but there needs to be the protection that it is done in an appropriate way and in an appropriate place. I think now we have that balance correct as a result of this particular amendment. In addition to that, and secondly, in relation to that matter, the committee recommended that it's important that regulations should be made, and that there should be provision to make regulations to cover the various ways in which all of this will operate. So that's also included in the improvements. And I think minor point, but in itself still very important. Now, the third improvement that I want to focus on is that difficult area of children giving evidence. And as Mr Clendid pointed out, this actually means people under the age of 18, so they're not necessarily infantile, and some of them may be able to give evidence in the ordinary way, and others will not be able to do so. And what we've got currently is a situation that doesn't really reflect that situation. So the improvements to Clause 32 does give effect to the presumption that a child witness does need to give evidence in alternative ways. That's an infant, in alternative ways, while at the same time ensuring that the defendant in particular, but also the judge, jury and other parties can hear the evidence given and will be able to understand it. So, as the law stands, a party other than the party intending to call the child witness may apply to the judge for a direction that the child is to give evidence in the ordinary way, but that's not quite enough. So what this improvement does is to amend Clause 32 so that it will allow a party other than the party calling the child witness to apply to the court for a direction that the witness can give evidence in the ordinary way, or alternatively in the alternative way. So that reflects the need to cater for both those witnesses who are capable of giving evidence in the ordinary way and those who really need to use the alternative methodologies. So that's, again, a fairly minor, but I think actually quite important improvement which has been made to the bill. Now, the fourth and last improvement that I want to focus on, I think, is the most important one. And we actually heard a submission by a particular person whose name I won't mention, but I felt it had particular relevance, and I think the committee did as well, and I felt that that submission was quite compelling in demonstrating, what can happen to a person if we don't get the law right in these respects. And what I'm particularly referring to is access to video records of evidence outside criminal or family court cases. And, Mr. Speaker, the truth is that some bodies, tribunals and so on, do have powers quite outside this legislation to call and consider evidence, video evidence, but are not subject to the regime which is actually prescribed by this Act and regulations. And injustices can flow from that. So the recommendations which were made and which I'm sure will be adopted by the Justice and Electoral Committee will ensure releasing a video record of evidence to parties to proceedings outside criminal or family courts, unless the relevant body orders it, is most appropriate. And I think it will operate to avoid the sorts of injustices which that particular submitter had been subjected to, and which can cause significant problems for such a person, particularly in their future employment prospects and so on. So again, it's a relatively minor improvement in itself, but it can have very important effects. So I think it needs to be mentioned as a particular improvement recommended by the committee that really needs to be supported, and I'm sure it will be. In addition to that, the amendment to new clause 33A will provide that the body concerned may order the release of the video record only if it would not jeopardise any pending criminal trial, and that it's in the interest of justice to do so. So I think that, again, we have here a balance. The balance being the need to protect individuals where for example, the police release this sort of information in a way that can be damaging to an individual, and that individual has no way of effectively preventing that damage from happening. On the other hand, there is a need for such information to be available if it's in the interest of justice to do so. So I think, that, again, that the balance has been achieved there. And overall, Mr. Speaker, I think that, as I've said, the Justice and Electoral Committee has done a very good job in reviewing this particular bill, in identifying some of the issues with it that needed to be corrected, and then has made some very sensible and worthwhile, perhaps minor in themselves, but nevertheless very important improvements to the bill, and we'll get a good piece of legislation as a result. New Zealand First will be very happy on that basis to continue to support it.
I call Chris